Good morning. We've got today Betty Zervas, so specialized solicitor and lawyer on property. Good morning, Betty. How are you?
I'm Nichols. Hello.
Good to see you, and thank you for coming. Look, everybody's been asking all these questions regarding conveyancing, and let's start off. Let's start away. You know, what is conveyancing? Because people are very confused. What's it all about?
Yeah, conveyancing. It's not usually a word that you hear very often, but so conveyancing is basically the legal transaction where you transfer the title from one owner to the other. And yeah.
And do we need a solicitor to do conveyancing, or I can do it by myself?
That's a very good question. And what I say to people are, you don't necessarily, there are solicitors that do conveyancing, and then there are conveyancers. There are just as many good conveyancers as there are good solicitors. There are just as many bad solicitors as there are bad conveyancers. So when you choose which one so in some transactions where it's just a matter of purchasing and selling, and you think that it's quite straightforward, you might think, okay, well, I only need a conveyancer, but at the end of the day, you need to pick someone who you have a good rapport with, because most people only have the opportunity of doing something like this once in their life. They might only be one home owner, and so the transaction has to be smooth, and it has to be and you have to be confident. So you need to really pick someone, whether it's a solicitor who does conveyancing or a conveyancer that knows what they're doing. It's just picking someone that you want to take through the journey with you.
Betty, what is the role of solicitor when buying a property? I mean, that's a bit complicated sometimes, but can you simplify it for us, please?
Yeah, well, there's different roles whether you're purchasing or selling. Okay, and you put a different hat on whether you're the solicitor for the purchaser or for the vendor. In this circumstance, if it's for a purchaser, and certainly with my clients, and I'm blessed that I work with quite a few buyers advocates as well, and so they engage me very early on, and certainly a lot of private purchasers do too, where and this is the most critical, and that's why I make a big mention of it, because it's not necessarily part of the conveyance. A lot of people think that they need to start looking for a conveyancer or a solicitor once they've signed on the dotted line of a contract, and I completely disagree with that, because I think when you do something, the preparation is actually the most important and critical part. So what I offer all my clients, and I think this is where the distinction is, I review contracts prior to the signing of a contract. So prior to you going to an auction, if you do have a physical auction to attend, or prior to you putting in an offer and signing a contract to submit your offer, I absolutely encourage and recommend that you get the contract in section 32, and I'll explain what they are, hopefully, if you ask me the question. But yeah, so the contract documentation should be reviewed prior, because there are certain things.
Sorry, can you have the solicitor acting for the buyer and the purchaser as well?
Well, there's nothing to stop that from happening, Con.
And conflict of interest, in other words? I mean, can you have conflict of interest?
Yeah. So I always avoid it, because I think there are plenty of parties out there, so that you're probably best to have a separate solicitor or conveyancer to the vendor, because they are conflicting interests. There's nothing to stop a solicitor acting for both, but they do need to have acknowledgements, and it's not really totally recommended. So no, I'd rather, if there was a purchaser and they were given the opportunity to go to the vendor's solicitor to act for both, I'd probably say you'd go and pick someone else. There's plenty out there.
What are the costs involved to do the conveyancing these days?
You probably have been around that there's some people that say $550. Plus disbursements. Is the plus disbursements that's the issue. And they can be quite open-ended. I like certainty. I think I like certainty and I think my clients like certainty as well. So I offer fixed fee conveyancing. So my fees are $9.90 plus GST, and then the cost of the disbursements. And the disbursements are the certificate fees, the search fees, things like that. They could be anything from $100 to $300.
At what stage do I need to pay fees and disbursements?
Yeah, so it all depends again with the engagement and with the conveyancer or the solicitor. In my circumstance, I carry the cost and get paid on the day of settlement. So that way, at least, there's so much going on when you're purchasing or selling, and there's more things to worry about. So the one thing that I do is carry the cost. At least then you know that you all put it into the final settlement day.
And a lot of people are very confused. What is the land transfer duty? What is it? Do we need to pay for it? Can we be exempted? What is it, the land transfer duty in other words?
The stamp duty, yeah. So stamp duty is something that's different.
For the land transfer, yeah.
Yeah, that's right. So stamp duty is the duty payable. So it's a tax payable upon the transfer of a product, so property from the vendor to the purchaser. We're quite lucky. So every state has its own duty and calculation and formula. With Victoria, there are certain exemptions. Now they keep changing. So what was available, certainly when I purchased my first property, there was full duty was payable. There were no exemptions. There were no first home buyers grants. I know I'm showing my age here, but yeah, so there were no duty exemptions or concessions, whether it's your PPR, which is your principal place of residence. So for example, at the moment, if it's 550,000 and below, and you're purchasing the property as your principal place of residence, so not first home buyer, that's separate again, then you have a stamp duty concession.
And it gives you all these incentives anyway, it gives you all these special grants at the moment to encourage you to buy a property.
Absolutely, absolutely. But there are, and the reality is though that what that means is that, for example, the 600,000 for the threshold for the first home buyer, well, it kind of then just lifts up the property prices of the one bedders or the two bedders that you get at that point. But what is really, really helpful, and what I say to my clients as a purchaser, the first app that you should download is the SRO, the State Revenue Office Victoria app on your phone, and that has a duty calculator. What people also forget is not only the duty is payable, and that's usually 5% of the, so that's quite a significant amount of money, but also the land registry fees they forget. So that could be anything up to $3,500.
Do I need insurance when I'm buying a property?
Okay, so what I recommend, and that's why it's always good to come to me before you sign. So with insurance, I always recommend as soon as you sign the contract, you have an insurable interest in the property. So yes, the contract might say that the property is at the risk of the vendor up till settlement. Correct. However, for the purposes of whether it's a 30, 60 or 90-day settlement, and I always recommend that you insure it, or at least with a cover note. So sometimes when you go to your the insurer that you have at the moment, or an insurer through your mortgagee, they might even provide a cover note. So it's obviously definitely, yeah.
So Betty, you put an insurance on a property that you don't actually own at the moment. However, yes, the title hasn't been transferred to your name yet. And although you still got to put insurance on it, are you still, I mean, knock on wood, if anything happens in the future and the house gets burned down, are you covered as a non-owner or as a interest on an ownership?
Yeah, right. You've got an interest in the property as soon as you sign that contract, and that's why you should really insure that interest. You've paid that 10%, and that's where so you have handed over good money for that. And also sometimes there's a legal argument of, well, what are you able to still get the legal document? So are you able to get title? Well, potentially yes. And it's sometimes what I've seen in the past, it's not about the burning down of the entire home, but for example, if there's been open for inspection, so people know that the property is vacant, we've had, for example, all the copper piping removed, which could be a new. So it's those kind of things that I'd say, for the cost of, you've spent so much money and paid your deposit for the sake of a couple of $100, if they charge you, because sometimes they have a cover note and it's for free, then you should definitely insure your interest.
Tell me, what are the title requisitions?
Yeah, so that doesn't really, so there used to be requisitions that you'd send across to the other side. That's all a little bit different now, Con. So yeah, there's no requisitions as such that you send over.
What actually always comes to me that what if the vendor cannot produce a certificate of title on the date of settlement? What happens then?
Right.
Can you still settle the property?
Yeah, if you can't provide title, then you can't have settlement.
But what about if you lost it or it got burned or it's missing, whatever may be the case? I mean,
yeah, believe it or not, that happens more often than not. The good thing about it now is ever since, and it's now most transactions actually take place electronically on what's called a PEXA workspace. So it's all an electronic platform. The good thing is that back a couple of years ago, we would all physically go to settlement, and that's when sometimes, believe it or not, on the day where we've all got the purchasers and the the purchaser's bank has got their bank checks all ready to go, and the vendor is meant to present their title, and we check the physical title, and we check the signatures on the transfer, and we check the contract signatures and the mortgage signatures, and there might be something that looks a little bit different, then we can't settle. So you used to hear that the settlement would just roll over or not be able to happen, or for example the vendor might have thought that they had the original title, but really it was just a photocopy. So that used to have that surprise factor and that risk factor. Now with the PEXA workspace, the great thing about it is that there are certain steps that and it's a little bit more transparent, where it all happens on the PEXA workspace. So
what if the title was lodged by the seller before settlement? What happens then?
Sorry, what if the
title was lodged by the seller before settlement?
Lodged?
Yeah.
Lodged with where?
They want to settle before, and they're trying to settle. However, during that they cannot find it. What actually is the settlement delayed, or what actually happens?
That's right. Okay, so the good thing now is that there's been a conversion of all the titles, the original duplicate titles. So there's one copy that's always held with the land registry or the titles office, and then that duplicate paper title. If there was no mortgage, then my vendor client would come to me ahead of settlement, would give me the physical paper title. I then convert it into an electronic one, destroy the paper title, have it as an electronic one. It's sitting in the PEXA workspace ready for settlement. Similarly, if it's the CT controller or the title controller is the bank, if there was a mortgage on the vendor's title, then they would produce that title and make it available in PEXA and have that ready for that settlement date. So things are a little bit different now, and certainly the whole move is that we're going to eventually not have any paper titles in existence.
Betty, we all know that by Melbourne or Victoria law, before you sell a property, you've got to have a vendor statement or 632. What if receiving the vendor statement and the information we receive from the vendor is inaccurate? What happens then? The information that we received, it's not proper.
Yeah, look, there's the Section 32, the name of it is also known as the vendor statement, and the vendor statement acts as a disclosure statement, Con. So it's meant to be, this is the legal disclosure about all things relevant to the property. And Section 32 of the Act, of the Sale of Land Act, actually stipulates what needs to be put in there. And you've probably heard from time to time that the vendor statement has been incomplete or misrepresentative.
What happens in this case?
It's voidable. So that's why it's really important. So I've just had a new matter today where I'm acting for the vendor, and we discovered that I've only just received instructions, and so one of my key questions are, have you made any improvements on the property in the last 7 years? Because I need to disclose any building permits and the like. So that's when they said, oh, well, yes, I've got a building permit and I've got the certificate of final inspection because it was a renovation, it wasn't a new build. But, oh no, I don't have a builder's warranty insurance certificate because I did it as owner builder. So part of the Act is, well, you cannot sell as owner builder unless you've got the relevant
the next question is a two-part question.
I'm a natural storyteller. I'm a lawyer. I talk. You have to let me talk. I'm a natural storyteller.
I know. Look, this question here, it's two-part. And what if the property is ready to settle and it's not vacant on the date of settlement? I, not vacant by the vendor, or B, the tenants are still there and they haven't moved out.
Yeah, so that's why the terms of the contract are really critical. So if the contract has been worded in that the vendor must give vacant possession, then that really means you must give vacant possession. Now, the good thing, or the critical thing with tenancies is where, for example, you've inspected the property, the tenant is in there, but the agent says, don't worry, the tenant will be out at settlement.
Okay.
What I always say to my clients is, well, this is really critical because you need to make sure that, for example, the tenant is out. And what I say is, make sure when you go back and do your final inspection, which is the inspection that you're entitled to in the last week of settlement, just prior to settlement, that you at least see the property the way that you're going to receive it. And that is without the tenant in there. So what I always say is a special condition to make sure that we're all on the same page and to be really smooth and tidy, is that we have a special condition to say that the tenant vacates the property at least 7 days prior to settlement.
What happens then?
Yeah, so if it's in the contract, we can do something about it. If it's not in the contract, then
But
technically...
But if it's in the contract and, I'm ready to settle, that a week before I did my inspection and the tenant or the vendor hasn't got no intention of moving out, what happens to the property? Do I still continue to buy the property? Can I cool off the deal, or can I get compensated?
Yeah, so and I've actually had this again just recently, where the vendor changed their mind, or we changed it back for them, but they had changed their mind on the sale. And the reality is that that's where, for example, the proper course was that we had a rescission notice that was served, and that allows the breach party. A rescission notice. Yeah, a rescission notice is a default notice. So either party can serve it on the defaulting party. So in this case, the vendor was not able to provide the property as per the contract on the day of settlement. So we serve a rescission notice that gives the defaulting party 14 days to settle, to affect the settlement. Conversely, if it's, for example, the purchaser, for whatever reason, at the moment, say they don't have their finance or can't get their finance together by settlement date, then the vendor would be serving a rescission notice. So you don't lose hope on the day of settlement, bang, it's all over. There's a rescission notice. You allow the defaulting party 14 days to affect settlement.
And finally, we got them out. So, and of course, I got the keys now. I walked inside the house and it's all damaged everywhere.
Yeah. So if you've proceeded with settlement on that basis, then it's bad luck, unfortunately. And that's why it's really critical. Sorry?
Can I claim the insurance?
Well, yes, that's where the insurance could come into it. Absolutely. Yep.
Even though I wasn't the legal owner of the property prior settlement?
No, but you're the policy holder. So if you've got insurance in place prior to settlement.
Betty, is there maybe you can give us a couple quick takeaways before we end this beautiful conversation? Is there something that you need to tell our buyers, mainly that before they buy a property, something very, very crucial to look at before they go ahead?
Absolutely. So I have I can go on for probably about 3 hours on this. So my tips are
3 hours.
Okay. Maybe we can break it down a few times. But so my main issue is that you go in and for the open for inspections, a lot of people come in and they're just so hyped about and on an adrenaline of the purchase, and they're too busy looking at the beautiful flower arrangement, the beautiful cushions, the artwork and the like. So they forget to do the critical thing. So the open for inspection is not there to see the interior decorating. It's there to ensure that you know what you are purchasing. So I always say, go in, make sure that all the appliances are in working order. Now, you might not be buying a brand new home, so you can't expect everything to be in working order, but at least if you take the time to inspect and switch on that air conditioner, switch on the oven, see whether there's the remote control for the split system, see if there's a remote control for the garage or the key for the side padlock. It's those kind of proper comprehensive inspection things that you can do there, because when you go back and do your final inspection, it's too late then to then produce a long list for me 2 days before settlement and say, oh, the balcony door isn't opening, or the, this and that's not, well, it's too late, because it's buyer beware, and you purchase it as it is on the day of sale, fair wear and tear accepted. So that's really important when you're not buying a brand new home, it's fair wear and tear accepted. And so the longer the settlement period, the more likely that there might be some fair wear and tear items. However, if you've done a comprehensive check at the start, then at least when you go back, it's a matter of making sure that there aren't any surprises. And then you just sort of know, for example, okay, well, I'm not going to go and buy that $5,000 couch because I will need to change that oven. So it's those kind of things that otherwise might leave a sour taste in your mouth on your first purchase or your property purchase if you aren't as comprehensive. And also, can I just one more thing? They're not watching me.
It's okay to see those visual things, but what about the non-visual defects, like termites, for example, that you went through the property, you never even realized that the ceiling or the flooring was termite. What actually happens then?
So I always say as well, make sure, and certainly especially with the COVID environment, subject to building inspection or subject to pest inspection is really quite acceptable. It's in the general form and general conditions of the Law Institute or the REIB contract. So make the most of it. If you feel like you're not at that level, or you don't have someone that's got a building experience background to know where to look for termites, for building inspections and defects, then absolutely put that into the contract and go and get yourself that report. Now, you don't want to do that with every property that you fall in love with, because that could be quite costly. But certainly if you're at the point that you know that potentially your offer will be accepted, then that contract can be subject to a building inspection or a pest inspection. And that can be critical. I've seen so often, especially first home buyers, where their decision, you need to understand that not all vendors are selling their pride and joy. Not all vendors are disclosing everything in that Section 32. Not all vendors have left the cracks that are on the wall. So there can be a lot of patch-ups and the like. So if you're not at the level that you can look at and find those defects, absolutely engage someone that will.
Betty, I think there's so many thousands of questions I can throw you right now. But before we go, where can the clients get in touch with you and give them more advice and help them to be the conveyancer or the solicitor on the future property they're going to buy?
Yeah, absolutely. Well, you've got my details, Con, so you can give them off to everyone that needs a good.
What is your company called, Betty?
So my legal practice is SZ Lawyers. So S for Sam, Z for Zebra Lawyers. And so it's szlawyers.com.au. My email is bettyz@szlawyers.com.au, and my mobile, which is available for anyone. If I am too busy, just an SMS and I get back to you straight away. It's 0411 47711. I'm really passionate, especially about first home buyers. So I'm more than happy to hold people's hand through the transaction.
Just one last question before we go. If they need any assistance to apply for the government grants, is it something you can assist them with?
Yeah, so I work hand in hand with the broker or the banker on behalf of the purchaser. And so that's all done through me. It's something that the purchaser does not have to worry about because I do it as part of my conveyancing so that they get all the concessions that are available to them.
Betty, a huge thank you. I believe we're going to do a lot more one-on-ones with a lot of the legal terms on property and real estate. And thank you for watching, everybody. Don't forget to subscribe downstairs to my YouTube channel. Until next week, enjoy the weekend.
Lovely. Bye. Happy spring, everyone.
Bye-bye.